Dungeons & Dragons has altered the deal. Pray they do not alter it any further. Because for years, Wizards of the Coast, which publishes Dungeons & Dragons, has operated under an open gaming license, an OGL, that allowed people to create and profit from unofficial content in the Dungeons & Dragons universe. Or does it? It's time to think like a rules lawyer. The idea is that the OGL is a legal framework that allows people to use the rules and ideas of the role-playing games to create their own works. And it was originally released in the year 2000s by Wizards of the Coast. And a lot of people have come to rely on the terms of the OGL to make and publish their own content under the aegis of Wizards of the Coast. But that was version 1 of the OGL. Now, according to a leak, version 1.1 of the OGL, which has not officially been adopted, makes huge sweeping changes that will affect anyone that makes content even related to Dungeons & Dragons. But this leaked version 1.1 update to the OGL is a mixed bag. It purports to crack down on sexist, homophobic, and transphobic content that is created with the Dungeons & Dragons name. It purports to grant a perpetual license to Wizards of the Coast for anyone that makes content using that license. It purports to require certain people who make content using that license to report that usage to Wizards of the Coast, and if you make over $750,000 in revenue, you have to pay certain royalties up to 25% to Wizards of the Coast on certain marginal income. These are big changes. Now, it's important to distinguish the OGL from the actual Dungeons & Dragons rules. The Dungeons & Dragons operates under a set of rules that's up to version 5e at this point, and the OGL is not the Dungeons & Dragons rules, and generally speaking, those rules are found in the System Reference Document, the SRD. That's a 400-page document containing just about everything you need to know about playing D&D. The main benefit of the OGL, whether you're talking about version 1 or version 1.1, is that it allows people to use and reproduce the SRD, the rules. But for people who make content that just simply works with the rules but doesn't reproduce them, well, there's a big question about whether you need the OGL at all. Now, we'll come back to that later. Now, these sweeping changes caused a huge uproar among fans and content creators alike. But like I said, it's a mixed bag. On the plus side, it provides a relatively clear path to allow almost anyone to create officially licensed content, and that's pretty rare. It's not like Disney says, sure, you can make any Mickey Mouse content you want, just pay us if you happen to make over $750,000 in revenue. And if these changes were coming from a position of absolute restriction, like Disney has a lockdown on their IP, then people would probably rejoice that they have this pathway to make officially licensed content and profit from it. But as it stands, we're coming from the opposite. We're coming from a world where almost everything was totally open, and these restrictions are causing a lot of consternation. So many people are upset about this leaked modified OGL. And the leaked OGL differentiates between commercial and non-commercial content. People making non-commercial content are fairly unburdened. And the leak says that making money via Patreon doesn't necessarily count as commercial. So that probably covers a large swath of people who might otherwise be upset about these changes. Now, I'm not going to dive too deep into the changes of this OGL. It's reasonably easy to understand to the credit of the lawyers who drafted it, and a lot of the coverage has already described what the implication of these purported changes are. And there are some issues as far as enforceability and promissory estoppel and reliance. Can you revoke a license that was granted in perpetuity? I'm not going to get into those. For a more detailed breakdown of the contractual provisions themselves, I'd highly recommend you check out the nerds over at Opening Arguments. They really go into the details of what the original and the leaked OGL say and what they don't say. It's absolutely the best breakdown of the contracts themselves. But I also think almost everyone is missing the biggest issue. And what I want to cover today is one of the more fundamental flaws with this whole setup, and I think frankly it changes everything. And as it happens, this whole controversy is a perfect opportunity to teach people about the difference between copyright and trademark. So, win-win. But the original OGL has been around for a while, and it was intended to provide an open platform for players. And for some of the critical background on that history, I turn to the D&D expert and uber nerd, Matt Colville.
The products that they make for Dungeons & Dragons tend to sell best to players. Well, adventures don't make a lot of money because only one of the 4 or 5 players at the table buy them, but you still got to make them. So his argument was, why don't we open these rules and make it so that anybody can make products for us? And that way, third-party companies will come along and they will make adventures for us. And they'll make other stuff too, but we don't care. And that way they'll support our product. And there was also some verbiage in there about how, and if those companies improve our rules and it's published under the OGL, then we can take those improvements, right? And then our game will improve. And that was a very egalitarian way of looking at things. And then fast forward, and Wizards of the Coast releases a 4th edition, which was very controversial and alienated a lot of fans. And so They sort of freaked out and released a 5th edition. 4th edition wasn't released under the Open Gaming license. It was released under a different license called the GSL, which was much more draconic and restrictive. And then 5th edition was released under the old OGL, which was much more open and broad and empowers people to make the stuff they want. Privately, the reason Ryan said he wanted to talk the board into opening D&D was because he did not like the idea that any one company would control this hobby. Right? He was like, I think D&D should belong to everybody, and this is the best way I can think of to make that happen. D&D is, I think, more of a folk tradition and a hobby than it is a classical brand. And it has always relied on the people who play it more so than any other game I can think of, except, perhaps like Skyrim, right, where there's so many mods for it. It's always relied on the audience to create content for it. Things like The Thief come from people playing in Los Angeles and coming up with a new class and literally calling up Gary Gygax on the phone and saying, hey, we got this cool idea. And he's like, oh, that's cool. I'd probably do it like this. And all of a sudden there's a thief in the game. Right. So that relationship between the players and the people making the game has always been a lot more gray and weirdly nuanced than almost any other game I can think of.
Okay, so with that background out of the way, let's talk about the difference between copyright and trademark. I promise it will be worth it. Now, copyright is a certain legal protection for expression. When you have an original work of authorship, whether it is a movie or a novel, and you affix it to a tangible medium, well, then copyright will protect that expression. Copyright does not protect ideas, it does not protect processes, it protects expression, whether that expression is in the form of words or a painting or a video. Copyright will provide quite a lot of protection. Trademark is about serving to identify the source of a particular product or service to distinguish that product from other sellers in the marketplace. The idea with trademark is you don't want consumers confused. You want people to actually know what they're buying at the time of sale. And trademark is a little bit different in that it can last forever. As long as someone is actually selling the trademark good, that trademark will continue for the protection of consumers. Now, Dungeons & Dragons as a tabletop RPG product involves both. It contains copyrightable pieces of expression, as well as trademarkable elements that are meant to identify it in the marketplace. Let's use a board game that everyone is familiar with, Monopoly, as an example here. The name Monopoly is trademarked. There is a long history of the Monopoly trademark that dealt with years and years of litigation. Let's put that aside for the moment. The logo of Monopoly is also trademarked. The official Monopoly board, the actual squares and everything on it, that's copyrighted. That is expression. It's as if it were a painting. And then sometimes within board games, you have specifically detailed characters that can be copyrighted. For example, in Monopoly, Rich Uncle Pennybags is a copyrighted character. And in Clue, you have Colonel Mustard. Those are copyrighted characters.
I'm only a guest.
But the name of the game, Monopoly, is trademarked. So you can't go out there and create a game called Monopoly and sell it, even if the rules of the game are completely different. But what about the opposite? What if you created a game that had a different name but followed the same rules as another game? Well, that takes us to the fundamental flaw of this whole entire controversy, which is that you can't copyright the rules to a game. You can't copyright a process. Now, this goes back to an extremely old copyright Supreme Court case in the late 19th century called Baker versus Selden, where someone tried to copyright a particular method of bookkeeping. In that case, a guy created a method of bookkeeping, i.e. accounting, and published a book about it. The book did okay, but it really took off when another person created another book of basically just forms that used the same methodology, but didn't credit the original person. The original author sued, but the Supreme Court said that there was no copyright available because you can't copyright a method. And that idea was later codified in the Copyright Act of 1976, which said, quote, "In no case does copyright protection for an original work of authorship extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of the form in which it is described, explained, illustrated, or embodied in such work." So, for example, if you wondered why everyone could play the game Words with Friends on Facebook, even though it was an exact clone of Scrabble, well, that's the reason. Scrabble can't have copyright protection over the rules of the game. It can only really get trademark protection over the name Scrabble, not the rules contained therein. Now, there is a little bit of a wrinkle here in the sense that if you had a manual of rules, you do get a thin copyright over the exact expression over the rules as laid out in that rulebook. However, you don't get a copyright over the rules and processes themselves. So in a sense, you can have something that has exactly the same mechanics, the same processes. It just can't necessarily have the exact same expression if you were to reproduce the rules perfectly, but that's kind of a minor quibble. So how does this relate to the Wizards of the Coast update to the OGL? Well, I think, and I could be wrong, that Wizards of the Coast is assuming that anytime anyone creates any content that happens to use the rules of Dungeons and Dragons, that it's covered by the OGL. I don't think that's the case. Now, this is not legal advice. Your mileage may vary, but as we discussed, you can't copyright the rules. You can't copyright the methodology and processes. And that takes us to the thing that no one is talking about. Here's part of the secret. The original OGL kinda sucks, and here's why. The main benefit of the OGL was that it allowed people to include the SRD, the system reference document, in their material. If your material doesn't require a reprinting or quoting of the SRD or the 5e rules, then you probably don't need the OGL. The original OGL allowed people to use what it called, quote, open game content, meaning, quote, the game mechanic and includes the methods, procedures, processes, and routines to the extent such content does not embody the product identity. Now, it did not allow people to use, quote, product identity, meaning, quote, product and product line names, logos, identifying marks, including trade dress, artifacts, creatures, characteristics, stories, storylines, plots, thematic elements, dialogue, incidents, language, artwork, symbols, designs, etc., etc., etc. So based on what we've already discussed here, I'm not sure that there was much benefit to the original OGL. It mainly allowed you to use stuff that you were already allowed to use, unless you wanted to actually quote the expression that was found in the SRD itself. And the new OGL does basically the same thing. The leaked OGL allows licensed people to use, quote, licensed content. It says usable D&D content, quote, licensed content. This is Dungeons and Dragons content that is included in the SRD version 5.1, including basic game mechanics, a curated selection of classes, monsters, spells, and items that allow you to make content compatible with Dungeons and Dragons 5th edition. And then the new OGL goes on to say, not usable D&D content, quote, unlicensed content. This is Dungeons and Dragons content that has been or later will be produced as official, that is released by Wizards of the Coast or any of its predecessors or successors, and is not present in the SRD version 5.1. Unlicensed content includes things like the most famous Dungeons and Dragons monsters, characters, magic spells, and things related to the various settings used in Dungeons and Dragons official content over the years. What the old open license content referred to as, quote, product identity. So both OGLs purported to let you use game mechanics of Dungeons and Dragons. And in my view, that's stuff that everyone was always allowed to use. But of course, the benefit of the OGLs, whether it's version 1 or version 1.1, is that it provides certainty. So there's that. But let's differentiate between two different types of content. In one bucket, you'll have what I'll call reproduction content. And in the other bucket, you have what I would call homebrew content. In this first reproduction bucket, you have things that would probably be considered from a copyright perspective, derivative works. That is, works that are based on a copyrighted property that Wizards of the Coast owns. So for example, if you made a t-shirt that features a character that is based on an official Wizards of the Coast Dungeons and Dragons campaign, and you put that on a t-shirt, even if you paint it yourself, well, that's probably a derivative work. And you need to get the permission of Wizards of the Coast. And to their credit, Wizards of the Coast has a fan art policy that allows fans to create fan art. And this is on their website, and I don't think it's changed. But also in this bucket is stuff that reproduces the SRD. Remember, I said that they do have a copyright over the actual exact wording that's in the SRD. And recall that both the original OGL and version 1.1 allow people to reproduce the SRD. So if your livelihood relies on actually reproducing the expression of the SRD, you would need to abide by the terms of the OGL. And I don't think that has changed. And maybe you want to quote large sections of the SRD to put it into a reference manual, or maybe you want to put the entire SRD into a PDF along with your original content. Say if you created an entirely new set of rules, but it starts with a basis of the SRD and you don't want to have people referencing back to the old SRD, well, that is probably covered. And to their credit, both versions of the OGL allows people to do that if you want to quote the SRD. It creates a pathway for that. But this reproductive bucket consists of things that are based on things that Wizards of the Coast can actually copyright. In the second bucket, and this is the thing that I think most people are upset about, would be homebrewed adventures and campaigns whose only connection to Wizards of the Coast is the fact that they use the rules in Dungeons & Dragons 5e. In this bucket, I'm kind of thinking about the things that you see on Critical Role or Dimension 20, where they create a campaign that is 100% original. The characters are completely new. The settings are completely new. And the only connection that these campaigns have to Dungeons & Dragons and Wizards of the Coast is that they rely on the rules that are set out in Dungeons & Dragons 5e. As we discussed, I don't think Wizards of the Coast has much protection over the rules themselves, the processes and methodologies contained in the Dungeons & Dragons rules. So if you create an otherwise original campaign, where the only connection is the fact that it uses the rules that are set out in D&D 5e, I don't think that runs afoul of the OGL. In fact, I don't think you need permission from Wizards of the Coast in any case. Even if you videotape and live stream that campaign, I don't think you need their permission. Because at the end of the day, Wizards of the Coast doesn't really have any kind of IP protection over the rules themselves. Now, admittedly, there's a lot of gray area here because it's not as simple as one bucket for fan art and one bucket for homebrew. Wizards of the Coast in D&D has all kinds of different characters. Some are pre-made. Now, arguably, those characters are often in the service of the mechanics of the game. They define the strength or speed or dexterity of these particular characters. But there's also backstory there. So does that create the kind of character that is protected like Colonel Mustard or James Bond? Or is that simply a rule in the game that functions within that rule-based universe? That's a tough question. But I'm also skeptical that the changes to the OGL affect virtual tabletops or Kickstarters as well. Again, the virtual tabletops are basically using the mechanics of the rules themselves, which I don't think Wizards of the Coast has much protection over. And same with Kickstarters over original campaigns and adventures. You know, again, if you're creating an entirely original world that just simply happens to use the rules of Dungeons & Dragons, I'm not sure that there's much that Wizards of the Coast can do about that. Though at the same time, if you are trying to do a Kickstarter over something that Wizards of the Coast actually has protection over, if you wanted to crowdsource a movie based on the mythos and lore of Dungeons and Dragons, that probably is going to be covered by the OGL. Though another gray area where I'm not sure where a court would come down would be, say, live streaming a playthrough of an official Wizards of the Coast Dungeons and Dragons campaign. Obviously, Wizards of the Coast publishes a number of official Dungeons and Dragons campaigns, and if you live streamed you and your friends playing through that, that is using official Dungeons and Dragons content over which they do have the copyright. That's a tough call. Though I would say that's analogous to live streaming a playthrough of a video game, which is also kind of a gray area. A video game is copyrighted. And it's an open question whether your playing through it is adding enough original content to be covered by fair use. And the same would go for playing through a Dungeons and Dragons official campaign. Though I do think that is a separate question from the kind of fully original homebrew type of situation that we were just talking about. Now, if you are a big player in the space, like Critical Role or Dimension 20, there might be some true advantages to making sure that everything is officially licensed by Wizards of the Coast, and they might not be able to avoid it. And certainly, if you are going to create your homebrews that are not officially licensed, you can't say that they are officially licensed, and you probably can't use the name Dungeons and Dragons, except in a nominative or descriptive fair use way, in the sense that you might be able to say something like, this campaign is compatible with Dungeons and Dragons, because even with trademark restrictions, you can describe a thing by its official name, but you're likely to be able to compare stuff and say that this is compatible with the rules of Dungeons and Dragons. You're just not allowed to say that this is from Dungeons and Dragons or somehow officially licensed. Anyway, that's just a theory, a game legal theory. And of course, the situation has now changed. Wizards of the Coast released a statement on dndbeyond.com on January 13th. In a tongue-in-cheek way, they said that they were cognizant of all of the pushback and, quote, rolled a 1. They say that, quote, the next OGL will contain the provisions that allow us to protect and cultivate the inclusive environment we're trying to build, and specify that it covers only content for TTRPGs. That means that other expressions such as educational and charitable campaigns, live streams, cosplay, VTT uses, etc. will remain unaffected by any OGL update. Content already released under version 1.0a will also remain unaffected. What it will not contain is any royalty structure. It It also will not include the license back provision that some people were afraid was a means for us to steal work. That thought never crossed our minds. Under any new OGL, you will own the content you create. We won't. Any language we put down will be crystal clear and unequivocal on that point. Now, not only have I been talking to tons of D&D players and GMs, I've also been talking to Wizards of the Coast lawyers. Now, there's tons of stuff going on behind the scenes, but all the lawyers will officially say is that their statement is sincere. Typical lawyers, just the worst. But look, it's great that they listen to the criticism. I'm sure that the changes will mollify a lot of what people are currently upset about. But I think the point remains, if you're only making content that is D&D compatible and doesn't reproduce their IP, well, maybe you never needed to comply with the OGL in the first place. Maybe the real OGL was the friends that we made along the way. Smoke bomb! Now, normally I would not cover a topic like this. This is way too nerdy, even for me, and it's way too in the weeds. Normally, a subject like this would be covered by fellow YouTube attorney Richard Hogue. A few days after Christmas, he suffered a stroke, was rushed to the hospital, and underwent extensive brain surgery. It seems like he's through the worst of it, but regardless, he's going to have an extensive recovery period. And Richard has always been a straight shooter, and his YouTube channel, Hogue Law, has always been a resource for insightful legal commentary on a lot of legal minutia. And his channel, as many of you know, is focused on the gaming and video game industry, things that Richard is incredibly passionate about. This is exactly the kind of video that he would have loved to have made if he'd been able to. His road to recovery is going to be long. His sister has created a GoFundMe page called Reasonable Minds Can Rebuild, because one of Richard's famous phrases is that reasonable minds can differ, because he wasn't afraid to offer an unpopular opinion, because reasonable minds can differ, especially when it comes to the law. And that's always been an incredibly admirable trait of his. So I'll put a link to his GoFundMe page down in the description and up on screen. If you're able to support it, it would mean the world to me so that we can speed along his recovery, because legal commentary on YouTube is just a little bit dimmer without his contributions. And then, of course, he can deal with all these friggin' nerdy questions about Dungeons and Dragons and Wizards of the Coast. Bunch of nerds. Cool kids play Magic.